One thing I would like everyone to do is, with the whole opioid epidemic, even the president's come out saying, this treatment as opposed to incarceration. Well, that needs to be a two-way street. And that's to Winnie's point about, people of color being treated, crack cocaine offenders, and they're getting treated much differently, have been treated much differently, as opposed to our others who are addicted to opioids getting treatment as opposed to incarceration. So one of the things I would encourage all of us to do is keep the pressure on saying that, look, if we're going to give these individuals treatment as opposed to incarceration, then the same people who are addicted to crack cocaine need to get those same benefits. So that's the one constant message I want our community to keep pushing out.
And along those lines, thank God the voters did vote for Proposition 36. That's where people who were charged with nonviolent third felonies were given life in prison if they had 2 prior strikes. I had a client who had 2 robberies when he was younger, and then his third conviction was for 0.6 grams of crack cocaine, and he was given a life sentence in prison. And with Prop 36, the voters had a say in that. And so now a lot of these, unfortunately, people of color were released from prison because, see, what people don't know is that crack cocaine was always a straight felony. It was never reducible. And typically people of color were convicted of cocaine possession charges or cocaine sales charges. And this was just possession, just allegedly having a rock. However, methamphetamine was treated differently. It was called a wobbler. So it could be charged as a felony or a misdemeanor. And typically clients that had methamphetamine were white and not persons of color. Same with heroin, typically Latino clientele, straight felony. There was a difference between how white offenders were treated when it related to substance abuse versus Black and brown people. And thank God Prop 36 came along and did away with it. But for about, 15, 16 years? I mean, my client did 16 years in prison for 0.6 grams of cocaine, probably the size of a Tic Tac. So, I'm just, those type of things do happen, but they're very rare and few and far between. But hopefully more of that comes down the pipeline. But that's just a clear example of how people have been treated differently based on color, unfortunately.
Yeah. I just wanted to say, this is Mac, and to the young lady who's been doing her research and everything, in California, there's, some of you are familiar with James Bell. I think he's up in Oakland, the Burns Institute. And there's a lot of research about, racial and ethnic disparities. They used to refer to it as disproportionate minority contact or disproportionate minority incarceration. But there's a lot of research out there where you can get information from state to state on, from the surveillance and to sentencing of African Americans and the disparities that exist.
Sorry, I muted myself. But I'm talking about like the association of drugs with the African American community causing this legitimate legitimization of racism.
No, it's interesting because, I mean, again, I've been a public defender for 22 years. And if I have a crack cocaine case, I know it is a person of African American descent every time. The heroin cases, I don't even need to look at a name. I know that it's a Latino person. It doesn't waver. Methamphetamine, white. Now, recent years, a couple of clients have been African American, but the vast majority of persons with methamphetamine typically are white. So I just find it interesting that the one drug that's, associated with people, with the white people, is treated differently. How come they get to have misdemeanors and people of color don't? I mean, you're done with the felony.
And even more so, the fact that it's a choice to the judge, kind of almost, right? Whether or not it is a misdemeanor or felony.
The legislature enacted that. So those are people in Sacramento that created the penal code that made these statutes. So these are respected people. These are lawyers. These are people who are educated. And to me, that is the most, it's just the most insidious thing, that you make these laws. I mean, you can do the stats, and what I'm saying is absolutely correct. So unfortunately.
Absolutely. Thank you very much.
Yeah.
Winnie, Winnie, can you talk to us a little bit about how plea bargaining works? Because some people think that the judge has a greater role in this, and he really does. Can you explain how the plea bargaining and negotiation works between the public defender's office and the district attorney's office?
I will. To be honest, the judge really has nothing to do with the plea bargain. You know, a plea bargain is basically an agreement between your client, it's not me, the lawyer, but it's my client in the district attorney's office. And like I said earlier, there are a lot of factors. The district attorney's office typically throws the book at people, which I find interesting that they decided to charge Derek Chauvin, knee on, you know, George Floyd's neck, starting off with third-degree murder. In California, you get the highest charge known to man, and it is up to you as a lawyer and your client to prove that they should get something less. So the district attorney's office typically throws the books at all my clients. I mean, overcharging cases routinely. And so by the time you get the case, you're like, oh my God, this is terrible. And even if the facts are suspect, and I know crap when I see it, I've read enough police reports, it's hard to fight sometimes because your client has has a long record. Clients typically will just plead to things just so they can get out of jail, which is the whole cash bail reform that's coming along, which I appreciate because a lot of people plead just to get out. But the plea bargain, so you know, you'll read your police report, get your discovery, and your client will say, look, I want to go to trial no matter what. We go to trial. Public defenders are not punks. So people have a bad perception of who we are. Oh, they just dump cases, they don't care. That's absolutely not true. We could certainly get a lot more money doing something else than to take the abuse that we get from everybody, from the DAs, judges, sometimes even the clients. But once we look at a case, I can assess it and I can see what the case is worth. And so I'll talk to my client and they'll say, look, I don't want to risk trial because of these issues, because I am on video. I did punch her in the face. Yeah, but you know, she said something to me, but it's just not a defense. Some cases really don't have, you know, they're just not defensible. And so the client may say, look, this is what I want. The DAs will say, well, this is what I'm offering you. And so sometimes it's close, sometimes it's far. And so you negotiate with the DA, you provide mitigation, you provide, you know, I'll appoint experts, maybe a ballistics expert to see if that weapon fired that gun, or a pathologist to see what the cause of death was, or, you know, a sex expert to see if the child was molested. I mean, all of these things I have to do to even get to a point of negotiation. Then once we're at that point, you know, the client can either accept what they're offering because it's what the district attorney is offering. The judge has no authority to make offers unless your client is willing to plead to the entire information. So the information is like the complaint form. And if there are 20 charges on that form, if you want to plead to the judge and bypass the district attorney, your client would have to plead to every single charge on that form. And if they're all strikes, that is just not a good disposition, especially when they're mandatory sentencing laws and there's nothing the judge can do for you. So 9 times out of, I'll say 9.5 times out of 10, I have to go to the DA. I have to. And so if there's a reasonable DA, we can work something out. Your client will get a disposition. He pleads. If it's not a reasonable DA and it's something crazy, you know, I'll tell my clients, don't take it. But sometimes clients are afraid. They're afraid of getting more time if they go to trial because that is a real possibility. So people can sit back and Monday morning quarterback what I do. But when your client is facing life sentence and they're offering your client 4 years at 80%, or 6 years at half, what do you think the client's gonna take? That's what's gonna happen. They're gonna take that deal. And unfortunately, that's how the cycle continues. And they keep taking deals, and then they have a long rap sheet, and then they're less desirable for a probationary offer. Because the DAs will say, oh, look at all these strikes, look at all these felonies on the record. He's going back to prison. And then they go back to prison, and the cycle never ends. And they end up doing life on an installment plan.